Please tell me how many permissions have the state granted to the number of protests, demonstrations that are going on to object the incident that has happened? How many formal requests have been made? The 14th of August 2024, the night, to reclaim the night by the women, did the police grant a single permission to anybody? And this protest is going on not only in the city, it is throughout the state, throughout the country, and has also crossed the borders. Right?
Yes. Yes.
How many have you given? Number one.
Yes. Yes.
Second, how influential is the petitioner? Since when is he doing all these activities? Prior to the Arjikor incident, was he known to people? Did he have any role, any type of significance, any antecedent as has been recorded in Arnab Goswami's matter?
Yes.
Next is, you say leader. He has to accept that he is a leader. It is just like Gaye Mane Na Apni Moral type of thing, right? He doesn't have any background and people will consider him as a leader, right? And you want this person to be kept in custody for whatever reason. The principal of the college where the incident took place, did the police take him in custody to find out what has happened? Can he not be considered as a leader of that organization? Is it not required? Next is the inflammatory speeches that you say, which were given by the petitioner, a petitioner's son rather. What about the inflammatory speeches that are being given out by the political leaders? What steps have been taken against them? This person, does he have any political inclination, any affiliation? Is he in active politics so that you can pin him down? Now, the people in general, in this incident, we are concerned about only this incident. Don't mix this up with other matters.
Correct.
One of a kind, shocked the conscience of the mankind, I may say, right? So in such a situation, when everybody is protesting, when the persons who are actually responsible for the incident or maybe was in a position to do something or not to do something, how many of them are in custody? These are just the general queries which passed on through the mind of the court when you are making submission. I just want answer to it.
But I'll try to dispel all doubts from the mind of the court.
Yes.
First is, the law requires permission to be taken. Your Lordship is right in saying that in these protests, how many permissions have been taken? Please come back to page 112.
Yes.
May I also just inform you one thing, that a number of permissions have been taken, a lot of
yes, I know that. I'll make those
petitions have been filed in this court.
Wherever permission has not been taken, what action the police has taken? Now, please consider, paragraph number 9, where the Supreme Court has said this court has permitted peaceful protests. Number 1. Therefore, the Supreme Court has permitted peaceful protests. If today, I go and apprehend somebody, in those cases where, we have not done so, at least there is no allegation. then we'll be violating the Supreme Court's order. Because the Supreme Court had permitted peaceful protest. Now, what is the difference between the other protests and this protest? But the difference is, Millard, that is what we had told them, that this is a high security zone where 163 or previous 144 has been imposed. The other processions, the other peaceful protests, wherever they are happening, whether Millard it is in the Southern Avenue, whether Millard it is in the Sambajar 5 point crossing, etc. Millard, there Millard 163 or 144 has not been imposed. Therefore, Millard, wherever there is a 144 imposed, possibly Millard, again going by paragraph 9 of the Supreme Court's order, it cannot be construed that orders under 144 is also to be brushed aside. But even then, Millard, assuming that our Millard interpretation of the Supreme Court's order is wrong, assuming for argument's sake, Millard, we have brought it to his notice or the three organizers' notice that please obtain permission. He has not obtained permission. Therefore, Millard, the other Millard protests which are taking place throughout the state, where Millard 144 is not involved. Millard, take an example, Millard, if something is to be organized, Millard, tomorrow, Millard, in and around, say, Raj Bhavan. But I'll have to ask people that please take permission. Or Millard, he could have come before this court and said that in view of the Supreme Court's direction, we are not to take permission. People are coming regularly before your lordship, Millard, whenever permission is delayed or refused. But now, Millard, may I just complete, Millard? What is usually not brought to the notice of the court is that when permissions are granted to various political parties. Otherwise, Millard, how could all these Millard agitations throughout the state by different political parties take place? Because in all those cases, Millard, permissions are granted. But they do not surface, because if you apply for permission, I give permission, why will the people come to court? People come to court, Millard, in fact, Millard, I have asked Millard, the competent authorities to make a list of how many permissions are given by the various districts for organizing these agitations, demonstrations, processions, etc., even during pujas. So that, Millard, we can give your lordship a picture that barely, Millard, even 0.5% of the applications are not refused. Therefore, Millard, the other agitations, Millard, which are taking place, Millard, if I today take action against them, Millard, it would be violation of the Supreme Court's order. Now, Millard, if today I have violated the Supreme Court's order, take an example. That in this case, by virtue of, Millard, this arrest, or by virtue of registering the FIRs, I have violated the Supreme Court's order, Millard, he has to go back to the Supreme Court, saying that the state has violated the Supreme Court's order. Now, he cannot, Millard, after accepting that he was the organizer or leader, whichever is the appropriate term, he cannot say that he is at par with the other accused persons in other cases. It is correct. My learned friend says that extraordinary. The extraordinary circumstances in the reverse manner. Extraordinary against him. Otherwise, if I release him today, but I have to release more than 150 persons.
What credibility does this petitioner have? Will you please say?
Millard, may I play one thing?
Kishore, please see your WhatsApp once.
Millard, accused for the first time is also equally responsible for the crime. One need not be Millard a history sheeter.
He claims he's a political worker. So that's please see your second paragraph.
Last one.
That last one that I just now sent on your WhatsApp.
Second paragraph.
First page. I am associated with
many social organizations like RSS, Vishnu Hindu Parishad, which is the youth wing of Bajrang Dal from South Kolkata. I am Milan Kendra Pramukh of Bajrang Dal up to 2023. I am a member of the new committee of Bajrang Dal, Shuman Kullan Das of 99 Ward. Also, and so he said that he is affiliated.
What is this?
What is this? What is this?
This is a statement under 161.
Achha. No, 161 statements are not to be laughed at. If you don't have 164, then there will be no prosecution.
I do not, as of now, I don't find him to be a very influential person who can garner so many people by only one call.
No, that is his admitted case.
Well,
it is his admitted case.
Let him admit. You have to find out whether.
No, we have our evidence, Milord. Milord, my submission is that in the backdrop of paragraph 10, he cannot say he is innocent. In the backdrop of paragraph 10, he cannot say that he is not responsible. And apart from that, Milord, my evidence is why I have picked him up, Milord, I'll place before the court. But not at the threshold that he should be let off. In the backdrop of paragraph 10, take it up on Tuesday or Wednesday. In one day, Milord, I'll file my affidavit in opposition.
Is his custodial interrogation so very important?
Very important, Milord.
What powers does he have to tamper evidence? Will he flee away, not give any witness when called for? These are the things which have been laid down by the Supreme Court at the
Definitely,
time.
Milord, in an appropriate, yes.
Right?
But in an appropriate case, where Milord, an accused comes and denies that I am in no way involved, in those cases, Milord, these parameters apply.
And one of the documents which have just been handed over by Mr. Banerjee here is a letter written by one Probir Das, who happens to be one of the persons in the same letter to which the petitioner was addressed, calling for the number of people to give details and seek for permission. Right? Now, this person, Probir Das, he mentions that with profound respect, please forward this to him also.
May I just see that letter once? Which one is that?
26th of August 24. Just now you handed over.
I'll just see it once.
Yes. Reply to 24th letter.
Yes,
reply
yes,
to 24th letter.
Right. It was forwarded. Possibly it was forwarded just now to you.
Because
no, I have not received it. Is it an email?
It was forwarded.
Yes, it's an email.
Yes, I forwarded.
Yes. It's an email communication.
Right.
Right. With profound respect, leave the first paragraph. The same would be a march towards Nobanno, the state secretariat, the student society, as well as the general public at large, irrespective of their caste, creed, religion, political identity, would be a part of this rally. The rally would be a means of a democratic and a non-violent protest. We have come to know from reliable sources that miscreants engaged by the ruling dispensation in the state would try and use tactics to defame the students and the general public at large by using violent and other malicious means. They would also take resort to various tactics to attack the protesters and the police personnel and defame the society. Steps may be taken to avoid such undesirable situation.
Right.
Not directly from Probir, but from one of the addressees to the notice. They fall on the same plane. I do not know whether you have arrested Probir or not.
Yes, he's arrested.
Yeah. He is also arrested. Very well.
And how many students were found in that agitation, everybody knows. Finally.
It has crossed the boundaries, Mr. Dotto. Everybody, not only students, children, women, men, everybody.
Milord, I would be, Milord, I would, Milord, try not to make any submission on those, because, Milord, that would be bordering on the merits of another case.
Yes. So let us not go into those.
Yes.
Therefore,
Milord, I very respectfully submit, Milord, this is an admitted case.
Yes.
He does not anywhere say that he is nowhere associated. He
Right.
points out fingers at the police. That's his case only.
But that is democracy also, isn't it?
No, democracy, Millard, the expression, Millard, democracy, Millard, I think, Millard, was best, Millard, explained by our late president, Mr. Pranab Mukherjee, who said India is a democratic country because all kinds of persons, Caucasians, Dravidians, uh, Mughals, the descendants of everybody can live together. I think, Millard, that is the best definition of democracy, Millard, that I've ever, Millard, come across. Now, Millard, here, Millard, again, Millard, democratic rights or fundamental rights under Article 19 is not unregulated and unrestricted.
But do
We
you
have,
not think that the manner in which you have treated this person is a pressure tactics not to continue with the protests?
Millard,
Persons who were actually responsible for the act for which they are protesting, they are yet to be identified, steps taken against them. Now you try to nab these people who are protesting.
no. Millard, kindly, Millard, do not, Millard, look at it from that point of view. But hundreds and thousands and lakhs are protesting.
Yes. And you
But
pick
in
up
those,
somebody who's
no,
trying
then no, Millard, in that case, Millard, people will go away. Well, it is one thing to, Millard, peacefully protest.
Yes.
It is one thing to, Millard, address your lordship. It is another thing to use unparliamentary language while addressing your lordship. Please consider the difference.
Yes.
Therefore, Millard, if 10 people agitate and 2 people of them, Millard, act in some other manner, but I have a right to, Millard, dissociate the 2 persons from the other 10 people. That regulatory right the police must have, otherwise, Millard, police will lose all its powers. Now, therefore, for example, the junior doctors, where the Supreme Court, Millard, has said, expected that the junior doctors will go back to work. In these orders, Millard, which my learned friend has annexed, the junior doctors have not gone back to work. Some of them, of course, have gone back. But we have not taken any steps against them. Yes, there are, Millard, certain, Millard, statements that is something different, but finally no steps have been taken. Therefore, Millard, if it is within the 4 corners of the law, any action within the 4 corners of the law, to the liking or to the disliking of the state, that is one thing. And if something is done beyond the 4 corners of the law, then, Millard, the police cannot be made numb by saying that you have not taken steps against the peaceful ones, therefore you cannot take steps against the persons who are not organizing it or conducting it peacefully. So that is what the Supreme Court says. Therefore, Millard, I very respectfully submit, Millard, that these are the matters, including this matter, in my very respectful submission, ought to be looked into by the Supreme Court. Because otherwise, Millard, the paragraph 9 of
till you bring this matter to the notice of the Supreme Court.
No, I have got no obligation, because my learned friend's client has brought it to the notice of this court.
Yes.
But my submission is, because before the Supreme Court, we are not parties. Supreme Court has taken suo motu cognizance of the matter. But I have got, Millard, different a different interpretation of the Supreme Court's order, but Millard, I have made that submission. Our High Court has not accepted that. Therefore, Millard, I will not dilate on that. Therefore, Millard, what I was trying to say is that we have acted, the Supreme Court was conscious that if I allow a peaceful protest, I should not tie the hands of the administration if it is not peaceful. Therefore, Millard, the paragraph 9 has been couched in that language. While, Millard, protecting the rights of the peaceful protesters, the Supreme Court was conscious that the administration should also not be stopped from taking action. Now, Millard, today, Millard, the administration has taken action. In 19 out of 20 cases, the administration has not taken any action because according to the administration, those are peaceful. Now, the one in which it is not peaceful, everybody knows that. Well, can it be said that a peaceful protest and a protest which is not peaceful should be dealt with in the same platter as that of the other one in terms of the
If
Supreme Court?
if the protest or the rally was initially peaceful and then somebody else hijacked it and made it unruly, why will you get hold of the person who organized the peaceful rally?
No. He's not only the organizer. He was a person who led it from Strand Road. It went on till Babu Ghat. At Babu Ghat, it became violent in his presence.
And Babu Ghat is Babu Ghat within the 144 zone? It
No,
isn't. Then
violence.
You find him to be very unruly in Babu Ghat. You arrest him.
No damage to. It's not unruly only, Milord. It's not only unruly, Milord. At Babu Ghat, Milord, several properties were damaged. Private properties.
Was he personally responsible
Yes,
for this damage? Did you find melting stones or anything?
Yes.
The photographs that have been produced.
But I do not know which photographs have been produced, Milord. The
I don't
instruction
know
that I have.
Do you find any of the photographs where this person?
They're coming in. We are not in.
So how do you know whether these photographs are related to this incident?
These are all as far as that incident, that place. All are of Strand Road.
I do not know.
Then you can put it on
affidavit. So that Milord, I will
put it on affidavit.
I will apprise the court by way of an affidavit. I am saying that give me 1 day time. Give me 1 day time.
Yes.
So he is not that innocent. This is an admitted case. Now, only thing which is troubling the court is his personal involvement.
Right.
But Milord, I have a twofold submission. As I said.
1 minute. And not only his personal involvement, he tries to make out a face of himself and somebody from behind is running the show. You don't get hold of the right person. You hold the person who is there in front.
Very well. Milord, may I, Milord, remind your Lordship, Milord, of the various orders that your Lordships pass. That when the state refuses a permission, somebody comes before the court, will your Lordships provide those conditions that give the name of the organizer? What is the purpose? If there is any damage, he is made responsible. Therefore, my lord, assuming for argument's sake, for the time being, that he had not destroyed any property, assuming for argument's sake that he was having both of his hands in his pockets when everything has happened, then also, my lord, in view of paragraph 10, my lord, he cannot say that I have no responsibility. And in fact, he has never said so. Please come back to my lord, paragraph 10 onwards, but I was emphasizing on that. But how can, my lord, these submissions be made in the court when there is no, my lord, averment to the indirect petition? But I am not, my lord, contesting a case where what has been said verbally is part of the pleading. But I am not taking.
You have to see that the writ petition has not been filed by the person who is in custody. It is the mother
Right,
who just comes
right.
So
therefore,
she may not have all information
no. But I have not taken that point whether the mother could have moved this petition or not. I have not taken that point. The Shayan Lahiri could have himself also moved the writ petition by furnishing a wakalatnama from the
custody. Yes.
Now kindly take me at paragraph 10 once more. Then kindly take me at paragraph 11 once more. Then paragraph 12 comes suddenly that several FIR has been registered within a short period of time. The state are entangling the petitioner's son in one after the other cases to harass him. The petitioner's son is aware of 3 other FIRs in which he has been arraigned as an accused, and he expresses his great aspersion that he will be shown arrested in such FIRs. One such FIR being etc. Where does he say that he was in nowhere involved? Then kindly take me to paragraph number 13. that a petitioner states that an investigation has been taken from Maidan PS by so-and-so to the shock, surprise, etc., overzealous police machinery, etc. Then 14, that the whole might of the state has been thrown into action to curtail the petitioner of his liberty by hook or by crook. The lodging of the instant FIRs are nothing but glaring examples of false implication, etc., etc., etc. Where so many high principles has been averred, but half sentence has not been said that the petitioner's son is in no way involved in any of these activities. The matter would have been completely different.
Paragraph 16, I can see.
Based on entire suspicion.
No, it says he is innocent and in no way connected with any offences, far less offences alleged against.
Yes.
So there
is essential that no role of the petitioner has been made out in the written complaint. Now, written complaint, again, FIR is not an encyclopedia of facts.
Yes, yes.
Therefore, if I have to make out a case 2 plus 2 is equal to 4, then no FIR stands. Therefore, in this entire thing, how can a person who organizes come and say that I've got no role to play and the petitioner has been picked up at the choice of the state? And why? Of so many persons, hundreds and thousands were there. Now, why will I pick up one unnecessarily when there are so many other accused or so many other persons? And in fact, we are still in the process of finding out the others.
Yes, your reply, please.
My reply, there is in the code of criminal procedure earlier code and a new code, there is not a single word your lordship will find that the vicarious liability. Your lordship will find in the IPC and a new BNS also that whoever committed the offense, he will be punished. This is the language always. So in the criminal
would your lordship permit me 2 more minutes? 2 more minutes. I think I need to show your lordship the Police Act.
Yes.
Where is the Police Act on the screen?
Yes, yes, yes.
If your lordship kindly take me section 30.
Yes.
The district superintendent or assistant superintendent of so and so, as occasion requires, direct conduct of all assemblies and processions on public roads or in public streets or thoroughfares and prescribe the routes by which and the times at which such processions may pass. Then the license part. He may also, on being satisfied that it is intended by any person or class of persons to convene or collect an assembly in any such road, street or thoroughfare, or form a procession which would, in the judgment of the magistrate of the district or of the subdivision of a district, if uncontrolled, be likely to cause a breach of the peace, required by general or special notice that the person convening or collecting such assembly or directing or promoting such processions shall apply for a license. Now, this was the letter that has been placed before my lord under section 30, subsection 2. On such application being made, he may issue a license specifying the name of licensees. If he had applied, I would have specified his name as one of the licensees. And defining the conditions on which alone such assembly or such procession is permitted to take place and otherwise giving effect to this section. So, had he applied, we would have made him one of the licensees, provided that no fee shall be charged. Now, kindly take, section 30, subsection A, section 30A. Any magistrate or district so and so may stop any procession which violates the conditions of a license granted under the last foregoing section, and may order it or any assembly which violates any such conditions as aforesaid to disperse. So, even after granting license, I can stop it. Any procession or assembly which neglects or refuses to obey any order under the last preceding subsection shall be deemed to be an unlawful assembly. Then section 31 I skip over, then kindly take 32. Every person opposing or not obeying the orders issued under the last 3 preceding sections or violating conditions of any license granted by so and so for so and so conducting assemblies and processions shall be liable on conviction before a magistrate to a fine not exceeding 200 rupees. Therefore, it is a direct responsibility. My learned friend's client's son cannot flatly refuse and say, no, I'm not going to make an application. That is what, Milord, Supreme Court is categoric, Milord, in paragraph 9. These are my regulatory powers. My learned friend says that there is no vicarious liability. I am not on vicarious liability, I am on the direct liability. Now the question is, he does not adhere to the law. He does not adhere to the Supreme Court's order. He does not take any license. Now he is only confined to saying that, where are the evidence against me? What is the direct evidence against me? You have picked me up out of nothing. But he cannot say so. He will give a call and then say that, oh, I don't have so much might to gather so many people. He may not have the might, but if he has called it, he has to take the responsibility.
Very well. It is enough. Please don't take any more.
More than enough.
Don't take any more strain. Take care of yourself. I would like to hear you in reply. First, tell me.
Yes.
We are talking about the son. How is the association that he is representing a registered one?
But this is not a registered one.
Not a registered association.
It is an association of people. It was formed because of the incident which took place
voluntarily
caused after 9th of August.
After 9th of August, just name it as an association. There is no association.
Because there are various part, the students were protesting. So they formed a group called, Milord, this association, Chhatra Samaj, was Paschim Banga Chhatra Samaj. So there are, Milord, different field and different, Milord, college, different, Milord, school. All the students, they have assembled and form a group to protest about the barbaric incident which took place on 9th of August.
And role of the
All right.
And by that.
And second, Lord, I told your Lordship, there is not a vicarious liability in Indian Penal Code offences and new BNS Act is concerned. So the sentence, whenever your Lordship will find a penal offence, your Lordship will find the sentence starting with whoever. So that person has to be taken responsible for the offence caused by that person. Now, my lord, from the submission of the learned Advocate General, your Lordship will not found there is single evidence in respect to present petitioner who actually, my lord, committed the particular offence. And if I take the, my lord, the face value of the submission of the learned Advocate General, only offence he has committed under section 32 of the Police Act, where, my lord, it's a penal offence and it is, my lord, only for 200 rupees. Now, my lord, keep these facts in one hand and, my lord, kindly take the parameters in Arnab Goswami's case, where your Lordship has the power to grant release him on interim bail. My lord, may I read the paragraph? My lord, whether I am, my lord, fulfilling the category of these paragraphs or not, your Lordship kindly consider. Number one, the nature of the alleged offence and nature of acquisition and severity of the punishment of the conviction. But it is, my lord, 64.1. The nature of alleged offence, nature of acquisition, and the severity of the punishment in the conviction. So, my lord, admittedly, so far as the offence of attempt to murder and other sections are involved, admittedly, there is no direct, my lord, the allegation so far as the present petitioner is concerned. If at all, my lord, I could gather from the submission of the learned Advocate General, the only offence which can be attracted to me under section 32 of the Police Act, which is a fine of ₹200 rupees.
No, further submission is that you've destroyed public property.
No, there is no evidence. So far as the present petitioner is concerned, there is no evidence. And your Lordships, that also, my lord, we can, my lord, counter that argument by that reply which forwarded to your Lordship. Your Lordship will find there is a specific column which has been written by the Chhatra Samaj saying that the outside
they anticipated that this could happen.
Yes, and that's what that was intimated to them. So they have their own, my lord, the IB, they have their own, my lord, the intelligence, Kolkata police. They could not find out who actually caused these offences. They should have, my lord. Kolkata police, sometimes we call, my lord, as a Scotland Yard. They have a better infrastructure. As soon as this mail has been committed, it was their duty to see who are the persons who are coming, who are the goons who are coming, who are trying to, my lord, disrupt the peaceful possession. That should be, my lord, looked into by them on that day itself. That we have intimated them. Second, my lord, 64.2. Whether this exists a reasonable apprehension of the accused tampering of the witness or being threat to the complaint of the witness. It doesn't appear because all the complainant belongs to the police.
No, you've read out. So
yes.
Don't repeat. Please don't repeat.
Well, these are the parameters when your lordship will consider my lord the interim bail. Let them file affidavit. What exact allegation, lord, they have against me regarding destruction of property, regarding attempt to murder. Let them place it. Then your lordship will deny. But in the meantime, lord, protect my liberty. This is my humble submission.
Very well. I'll pass order. But then in my chamber.
Lordship. Lord, 3 cases have been tagged. Lord, kindly mark, Lord, the paragraph 12. I have mentioned all these 3 cases. Para 12.
You relied upon Arnab Goswami and Bikash Singh.
Para 12 of my petition.
These are the 2 precedents that you have relied upon.
Yes. Paragraph 11. Para 11. Para 11.
Maidan police station arrest.
Lord, 11, 12. I was arrested in connection with Lord, the Maidan police station. In subsequent para 11 and para 12, these are the 3 FIR I am directly named. Lord, kindly release me so far as these 3 FIRs are concerned, if I am at all arrested. And so far as the other cases, protect me till they file their affidavit.
State. Get me the Police Act in my chamber.